Hello beautiful people, welcome back to our channel. Nnamdi Kanu has finally made a powerful move that will change all the narrative he's been looking out for. And we're going to give you full details on what just transpired a few hours ago. And of course, all the affidavit in court that was also sworn in. And what has been trending is the fact that Justice Omotosho is now being placed on hold. Justice Omotosho must hear the motion to arrest Judgement before proceeding. Now, a lot of things have been said concerning this motion about arresting Justice Omotosho's judgment. But let's find out exactly in legal terms what it means. Well, according to the Global Defense Consortium of Nnamdi Kanu, there seem to be the non-derogable right to fair hearing and the rule of law. Let's quickly dive into the full news. Now, they said, number one, that the motion to arrest Judgement is a lawful binding judicial process. On the 10th of November 2025, the defense of Nnamdi Kanu filed a motion to arrest Judgement before the Federal High Court, Abuja, presided over by Honorable Justice James Omotosho. Now, the motion is not political theater. It is a recognized legal procedure in Nigerian criminal jurisprudence designed to prevent a court from delivering judgment where jurisdictional or foundational defect remains unsolved. Although the phrase arrest of judgment appears in procedural legislation such as the Administration of Criminal Justice Act, which is ACJA 2015, its constitutional foundation rests on Section 36, subsection 1 of the Constitution of the Federal Republic of Nigeria, 1999, amended, which guarantees every person the right to be heard before any decision affecting his right or obligation is made. Now, to arrest judgment is therefore to compel obedience to the Constitution, to ensure that no judgment is delivered in breach of the right to fair hearing. It is lawful, binding, and time-honored judicial safeguard against miscarriage of justice. 2. Fair hearing is non-derogable and universal binding. Now, fair hearing is not a privilege granted by a court. It is an oxygen of justice itself. It cannot be suspended, it cannot be diluted or deferred, not even by judicial convenience. Now, in Kotoye vs. CBN 1989, at 448, the Supreme Court held that fair hearing lies not in the correctness of a decision, but in the opportunity afforded to be heard before the decision is made. A judgment delivered while a live motion, especially one that questions jurisdiction or competence is pending, is constitutionally void. To ignore such a motion is to act in defiance of Section 36, subsection 1, and to deliver a verdict without legal life. Why this motion matters now? Justice Omotosho has announced his intention to deliver final judgment on the 20th of November 2025, even though several pending motions remain unheard, including the motion to arrest Judgement filed on the 10th of November 2025. Now, these motions directly question the court's jurisdiction, the substance of any valid charge, and the validity of the plea entered on the 29th of March 2025. Now, to proceed to judgment without determining them would be to pronounce upon nothingness a legal absurdity. Now, setting the record straight, Kanu has entered his defense. The persistent claim that Nnamdi Kanu refused to enter defense is false and misleading. He entered his defense fully within the of law by subjecting the prosecution's witnesses to rigorous cross-examination, during which their credibility and the integrity of the government's evidence were demolished on record. Under Nigerian criminal procedure, cross-examination of prosecution witnesses forms part of the defense's evidentiary case. Having dismantled the prosecution's case under cross-examination, Kanu has no obligation to call witnesses in defense of a charge that itself is a nullity. What he has declined to do is to call witnesses to validate a non-existing non-existent charge because the Terrorism Prevention Amendment Act 2013, under which he was purportedly tried, has long been repealed and supplanted by the Terrorism Prevention Prohibition Act 2022. He cannot defend himself against the mirage. The legal consequences if the motion is ignored. If Justice Omotosho proceeds to deliver judgment without first hearing and determining the motion to arrest judgment, he will have denied the accused a constitutional right to be heard. He will have acted without jurisdiction, as the competence of the court remains under challenge. Any such judgment will be a nullity ab initio under established authorities, including Madukolo versus Nkem Dilim, 1962. To deliver judgment in the face of an unventilated motion is to depart from the path of legality and to descend into judicial self-help. The broader constitution states this case is not about one man. It's about whether Nigerian courts will uphold supremacy of the Constitution. The motion to arrest judgment is a procedural shield for the judiciary itself, preventing it from issuing a judgment that will later be voided for constitutional infringement and infraction. If that shield is cast aside, judicial legitimacy collapses. Our call to conscience. The Nnamdi Kanu Global Defense Consortium calls upon the Federal High Court to hear and determine the motion to arrest judgment before taking any further step. The Nigerian Bar Association to defend the sanctity of fair hearing as the lifeblood of justice. The media and civil society to resist the misinformation and uphold the truth, and the international community to note that the right to fair hearing under Section 36 CFRN and the African Charter on Human and People's Rights Cap A9 LFN 2004 is non-derogable and binding. Justice Omotosho stands at a defining juncture to affirm the supremacy of the Constitution or to risk being recorded in history as the judge who pronounced judgment over silence. In conclusion, the motion to arrest judgment filed by Nnamdi Kanu is a lawful and constitutionally compelled act of self-defense. It demands that the court obey the rule of law before it talks in the name of justice. Until that motion is heard and determined, no valid judgment can issue in FHC/ABJ/CR/383/2015. To proceed otherwise would be to trample upon the very foundation of Nigeria's constitutional order, the non-derogable right to be heard. Of course, all of this is signed by Nnamdi Kanu Global Defense Consortium. They have already filed the case, and this must be heard before Justice Omotosho will start considering, the verdict of 20th of November. How this will play out, of course, and Nigerians are watching, and the world is also watching. Let's meet in that conversation. So